Thank you very much. I welcome everyone to this, the Justice Committee's 6th meeting in 2014. I can ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when switched to silent. No apologies have been received. Item 1, I'm inviting you to agree. Item 5, in private, our approach to stage 1 scrutiny of the Courts Reform Scotland Bill. Are you agreeable? Item 2 is consideration of 2 negative instruments. The first is discontinuance of Aberdeen and Peterhead Prison Scotland Order 2014 SSI 2014/13. This instrument formally discontinues the prison at Aberdeen and Peterhead. The Delegated Powers and Law Reform Committee didn't have any concern with this instrument. Do members have any comments to make? No. I intend to make no recommendation in relation to the instrument. Thank you. The second negative instrument is the Act of Suddent Fees of Solicitors and the Sheriff Court Amendment 2014. SSI 2014/14. This instrument provides that all monetary values and ordinary causes are expressed as a multiple or fraction of the new rate of £156 per hour. I don't know what that means, but there we are. Do you know what that means? Yes? Rod does. Again, the DPLR Committee had no comments on this instrument. Do members have any comments on SSI 2014/14? No comments. Thank you very much. Item 3. Scottish Human Rights Commission. It's an evidence session with the SHRC on Scotland's National Action Plan for Human Rights, and I welcome the meeting from the Scottish Human Rights Commission, Professor Alan Millen, Chair, and Sheila McCall, Commissioner. Good morning. I understand, Professor Millen, you want to make a short opening statement. Please feel free, and then I'll take questions from members. Thank you.
Well, thanks very much, Convener, and to all members of the committee. I very much welcome this opportunity to open up a dialogue between yourselves and the Scotland's National Action Plan process as it unfolds over the months and years ahead of us. I hope this is just the first engagement that we'll have in that context. Thanks for the opening few minutes just to maybe highlight some of the areas that it would be worth to explore today and going forward. Questions really as to what is SNAP, as it's become known as, why does Scotland need it, what will it do, and what does it mean for you? The inspiration that has driven Scotland's National Action Plan to where we are at this stage of its development comes from the words of Eleanor Roosevelt, which some of you may already be aware of. She was the co-architect of the Universal Declaration of Human Rights in 1948, the foundation of all human rights law and values as we know them today. And what she said was, "Where, after all, do universal human rights begin? In small places close to home, so close and so small that they cannot be seen on any maps of the world. Yet they are the world of the individual person, the neighbourhood he lives in, the school or college he attends, the factory, farm or office where he works. Unless these rights have meaning there, they have little meaning anywhere. Without concerted citizen action to uphold them close to home, we shall look in vain for progress in the larger world." That encapsulates what the ambition of SNAP is, combined with a pragmatism as to how we can best and most effectively get there. It's a process which has been led by the Scottish Human Rights Commission, but it no longer belongs to the Scottish Human Rights Commission. It is now a shared responsibility because it's Scotland's National Action Plan and belongs as much to you as it does to the Scottish Human Rights Commission and the rest of the country. So what is SNAP? Well, its vision is very straightforward. It says Scotland should become a country where everyone is able to live with human dignity. Its purpose, a practical roadmap for the progressive realisation of internationally agreed human rights, so as to enable all of us to live with human dignity. It was launched on December 10th, International Human Rights Day in 2013. Some of you may recall there was a debate in this very building in the Chamber on that day, and cross-party support was very evident. Present on the day of the launch, representing the Scottish Government, was the Deputy First Minister, and representing the Council of Europe, its Human Rights Commissioner, Niels Muijnieks. SNAP is in its very early stage of development, but it's already attracted significant international interest. Just next month, there's going to be about 10 other countries around Europe brought to Strasbourg to learn from the experience of Scotland's National Action Plan and to hopefully give them some guidance as to how they might do something similar. The United Nations Office for the High Commissioner in Geneva is also very supportive in promoting it to other countries. It's not a traditional action plan with which all of us might be familiar, either a tick list that comes down from on high about what a government's prepared to do and not do, nor is it an unrealistic wish list that comes up from below that doesn't have any evidence base or chances of being effectively implemented. It is a collaborative process, a transformative programme of action to bring about sustainable culture change. It meets international best practice for three reasons. It's evidence-based, and I'll come to that in a second. It was inclusively developed, a drafting group consisting of a wide range of public bodies from the government and the NHS and COSLA through to STUC, SCVO, Health and Social Care Alliance, and Amnesty International. Its implementation will be independently monitored. Indicators will be developed, and that process will be overseen by the former Auditor General, Bob Black. Why does Scotland need an action plan? Well, the Scottish Human Rights Commission, for the first time in Scotland, carried out over 4 years a mapping of just where human rights are in Scotland, to what extent are they realised, particularly by the most marginalised within our community. We published the findings of that and shared that, and that led to a process of participation as to whether those findings were accurate, and they were largely affirmed in public interaction. The conclusion of that mapping was Scotland has made progress since devolution, but could do better. And if you take a sort of traffic light system, in terms of the structure of Scotland's governance, legislative process, in other words, to a large extent, mainly green lights. Because of the Scotland Act and the Human Rights Act, almost all legislation was in compliance with those contexts. When it came to process, that is, implementing legislation into policy or strategies, mixed, green turned to amber more often than we wanted. But when it came to outcomes, the actual living experience, amber turned to red. There wasn't consistently the good intentions of Parliament's legislation being turned into good practice. Where a human rights-based approach had been used, that is, where people were empowered to really understand what their rights were, where public authorities understood how to meet their duties and how to implement them, then the outcomes for people were better. And so a human rights-based approach is seen as being the agent of change for the realisation of SNAP. Just moving towards concluding my opening remarks, how will it be implemented and become closer to the Justice Committee in this regard? 3 outcomes were agreed that Scotland should strive to achieve a better culture, better lives and a better world. 9 priority areas were also agreed, including justice and safety. Common issues of interest to you would be policing, corroboration, victims' rights, violence against women. In order to identify concrete actions in all of these areas, human rights action groups are now being put together, again representing the breadth of public life and civic society. Innovation forums will be held to examine best practice within Scotland and beyond Scotland, and the whole process of implementation will be overseen by a leadership panel, which will report annually to the Scottish Parliament in order that progress against objective indicators can be measured and debated within the Parliament. What does it mean for you and for the Parliament as a whole? It would be very, very helpful to the process if the Justice Committee were to take an interest in facilitating Parliament having an annual debate when the annual report is presented. The first one will be towards the end of this year, just prior to December 10th, International Human Rights Day. A second way would be for the Justice Committee to consider, because of the commonality of various issues that you're concerned with and that SNAP will undoubtedly be seeking to progress, perhaps considering establishing a rapporteur within the Justice Committee to have an ongoing dialogue with the SNAP process and an exchange and free flow of information. And finally, to help the Scottish Parliament as a whole meet its responsibility to monitor the implementation of international human rights legal obligations by Scotland. You probably won't need any better example of the need for this to be done than the whole episode over the last couple of years, from maybe the 3 Cs, from Cadder to Carloway to corroboration. Now, that process would not have been necessary, painful as it has been for many of us, if more attention had been paid and more respect given to recommendations that had come from international human rights bodies 10, 15 years ago, pointing out that this was something that had to be addressed. So a more proactive engagement and improvement of monitoring international human rights recommendations would do well for the committee, for Parliament and for Scotland as a whole. Thanks very much, Convener. I don't want to take up any more time because I really would welcome as much dialogue as possible, and I do hope this is just the beginning of that relationship between the Justice Committee and SNAP. Many thanks.
Can I see any members wish to ask questions? Elaine? Christian? Sandra? For starters, Elaine.
Yes, you made reference just at the end of your statement to some of the issues we've been having to try and make our way through recently with the Criminal Justice Bill, where there almost seems to be a conflict between the human rights of different groups, the human rights of the victims in terms of having their day in court, and the human rights of the person who's been accused. I just wondered how this type of approach that you are advocating might have assisted in this process, because it has been very difficult. Either, whatever the decision is made, somebody is going to feel that their human rights have been disregarded, if you like.
Thanks very much. I'll ask my colleague Sheila McCall to address that.
I think there's 2 ways to look at that issue, and the question you're asking is how would this approach have helped in that process? It would have helped in this sense. What we are seeking to do through the SNAP process is to put human rights at the heart of the development of law, the development of policy and strategy, and then the implementation of that on the ground. And the process seeks to build consensus among those involved in that, both those that have to deliver and those that will receive services at the other end, those whose human rights are directly affected. So understanding what all the international human rights obligations are informs that process from the outset, rather than, as happened with Cadder and Carloway, being reactive. So it allows the Parliament and policymakers and so on to be proactive, because it increases their knowledge of international human rights. It allows them to see the connection then with the domestic policy situation. The second way in which this process is involved generally in that issue you've been talking about is one of the steps that's been agreed as part of the action plan so far is that the Scottish Government, along with others, including the Commission, will monitor the human rights impact of the criminal justice reforms that follow from Carloway and so on. And that will allow the opportunity for scrutiny after that legislation is passed to see just whether the impact on the ground is what it was intended to be, or whether problems have arisen that need to be sorted. So it comes at it from both ends, I think, to assist.
To a certain extent, it's coming, if you're reviewing it afterwards, if there are problems, then you're reacting. Again, we're reacting to problems rather than foreseeing problems. Can I just ask, have you been invited onto Lord Bonamy's review group? Will you be taking part in that?
Not as yet, but I understand an invitation may be coming.
Maybe in the post. Good. In particular, you make points about, important points about victims' rights. And you talk about the Scottish Government's review on violence against women. Are there particular issues that we should be aware of in terms of victims' rights not being respected during the court process? Have you any advice you can give us in terms of looking at some of those issues? No, it's not so much about the Victims and Witnesses Bill, but in terms of future strategies and looking at particularly, victims of sexual and domestic abuse. Are there particular human rights approaches that we should be seeking to see demonstrated?
Well, one of the things that's been recommended by the UN Committee for the Elimination of Discrimination Against Women is that while Scotland, the government, is developing a strategy on violence against women, it needs to be complemented with an action plan. So there needs to be concrete steps identified so that everyone can see what is going to achieve the outcome sought, what steps are going to be taken, and government and others can be held to account against that action plan rather than against a kind of broader strategy. So one of the aspects under SNAP Priority 6, which is the justice and safety priority in the Better Lives outcome, one of those parts relates to the development of that strategy and the action plan. And the Human Rights Action Group in that area will convene and bring parties around the table to try and identify the sorts of steps that should be taken to bring up precisely the issues that you're alluding to.
Yes, thank you. Christian, yes.
Yes, good morning. Thank you for coming. I just wanted to ask a personal question, more on the international interest. You say that Scotland has made great progress since devolution. That was quite interesting, but when you talked about the beyond Scotland, and I wanted to know, the way I read the papers, are we that groundbreaking in the world? Is SNAP really something that is recognized across the world as something new? If you could answer that first.
Yes. Just to put it in context, then 20 years ago, the United Nations called for all countries to develop national action plans. 4 years later, we had the European Convention of Human Rights incorporated into UK and Scottish law. Then we had National Human Rights Institution established. The next step, therefore, is for that institution to have led a process of Scotland developing its action plan to join about 30 other countries around the world, although it is the first within the United Kingdom. International best practice has developed as to how you best do that. There should be an evidence base, and that was the 4 years' work that the Commission carried out doing the mapping. It should be inclusively developed, and this has been a distinctive feature in Scotland, bringing together the government, public bodies like the NHS, the Care Inspectorate, NGOs, civil society, around the same table to identify what needs to be done and how can it best be done. And then the third, independent monitoring, and to have someone like the former Auditor General being overseeing the development of objective indicators to measure the progress that we and the rest of the world can then gauge, well, what difference, what impact is it making. So that process, even though it's still at a very early stage, as I say, has attracted a lot of interest. Council of Europe convening a round table next month in Strasbourg to look at Scotland, as well as Finland and one or two other countries in Europe, and the United Nations promoting it as being an example of where other countries can come to learn as to how the process is done. The Scottish Human Rights Commission is one of over 100 national human rights institutions around the world, and again next month in Geneva, all of them will be looking at how Scotland has progressed to this stage and seeing what lessons there are for their countries.
I just find it difficult to understand. I'm new in the committee, but when we were through CADA and when through a lot of our recommendations, there were a lot of international examples. And we found it difficult. It's easy to compare legislation one by one. It's more difficult to compare a judicial system when the implementation of legislation is again more difficult to compare. I just wonder how we can compare culture change internationally. I found the concept maybe a bit difficult. How are we going to monitor and understanding how much the culture change is happening in Scotland compared to other countries? Could you maybe develop on this?
It's one of the challenges that is being faced and addressed, and the innovation forums that SNAP will be developing will look at that as well as many other questions, learning and contributing to the development of best practice in, firstly, what are the objective indicators to measure economic, social, cultural, civil and political progress and implementation of internationally recognised rights, and also what are the means of capturing not just the statistics, but the living experience of real people, particularly those with the least voice in the community or in the most remote areas or with disadvantages. So capturing that human element along with the objective indicators is very much what's on the table for SNAP, learning from others and contributing to increasing the ability for all of us in the world to sharpen that tool that is so necessary.
I'll move on. Just Sandra, followed by John Finney.
Thank you very much, Convener. Good morning. Can I just say I'm delighted in the publication, and I remember from a number of years ago the ambition of a commissioner and yourself, Professor Miller, was not necessarily to look at some of the issues that were produced in the newspapers, such as slopping out. It was more to do with people, and they couldn't get justice in that respect. So I'm very pleased that this has actually been produced, and we're looking at, as you had just mentioned there, live experiences of people. One of the questions I wanted to ask, having read through the report, is about the outcomes. And outcome 2 obviously has 3 action groups, and one of the action groups looks at justice and safety, which is obviously pertinent to our committee, and the Human Rights Commission will oversee the finalisation and publication of justice for victims of historic child abuse and obviously violence against women, and the action group will seek to ensure that it's real live experiences that's been brought forward from that. I just wondered, and I wanted to ask yourself, Professor Miller, and perhaps Ms McCall as well, are there any areas of the outcome 2 which should be prioritised? Do you feel some should be prioritised before others in regards to the justice and safety? And what role do you envisage the Justice Committee having within any replies to that, or evidence taking, or anything like that?
Yes, I mean, I'll certainly kick off answering that, and Sheila can come in. You mentioned one example, I think, which does have a compelling dimension to it, and I know many of you from your constituents' mailbag will have this. That's the victims of historic child abuse. Something has to be done as a matter of urgency. The dignity that those survivors have shown over the years is remarkable, but it can't be the only positive thing that can be said about how the victims of historic child abuse is being addressed in Scotland. It is a good example of how a process bringing around the table those with the real sharp life experience and those who have the responsibilities to do something about it. The Commission has facilitated an interaction process specifically in that area, brought people around the table for the first time, victims, nuns, government ministers, local authorities, to identify what is an agreed way forward of delivering justice to those victims. We're now on the cusp of the government responding to that draft action plan, literally within the next month or 2, and that will be a very early indicator within SNAP as to what progress, if any, is going to be made. We also have sitting among us Margaret Mitchell, who is working on a private member's bill for an apology law. That is very much part of the draft action plan that's been agreed by all around the table as being something that really needs to be explored. And it's very good that Margaret Mitchell is doing a lot of the heavy lifting in this, but it's also the government's responsibility to ensure that this is progressed and support is given to it. So that will be an early test, an early outcome that will be measured and will be reported to Parliament towards the end of this year.
I think there will be, just following on from what Alan's just said about the historic abuse remedies, there may be a number of pieces of legislation that end up before this committee for scrutiny, or for which this committee might be interested in hearing evidence about. The apology law has been mentioned, issues about prescription and limitation to enable survivors of historic abuse to access civil justice. There's also a benefit to, Alan described earlier, as a rapporteur system, someone to liaise between this committee and the SNAP process. There's another way in which that sort of system in this context could help, because in the Victims and Witnesses Bill, which this committee has been scrutinising to some extent, the government proposes forming a national confidential forum for survivors of historic abuse. That part of the bill finds itself in the Health and Sport Committee. There's a danger in that situation that the Health Committee isn't scrutinising that part of the bill from the perspective of the impact on human rights. And this committee may wish to take an interest from that perspective to ensure that the human rights implications don't fall between the cracks. That's a benefit of the sort of rapporteur system that we're talking about. But in terms, Ms White, of your question about prioritisation, what the action plan does do in the justice and safety sections, it sets out some agreed actions for 2014. This is a short, medium and long-term goal process. So obviously actions will continue to be developed and prioritised by the Human Rights Action Group. But one of the examples where this committee already has a mechanism in place to assist in the process is that Police Scotland have committed in 2014 to identify opportunities to further embed human rights within their structures and culture of policing. And that includes looking at training issues and so on. Now, this committee, I'm aware, is hearing evidence about the implementation of Police and Fire Reform Act. That's an opportunity to question the police about what actual steps they're taking in that respect, what commitments they're prepared to make, and monitoring the progress of that. So that's a very real example of how this committee can engage within its existing agenda with the SNAP process.
I was going to ask about other committees, but I think Ms McCall has mentioned that, how other committees could work with this committee. But you've already answered that question. And
well, I think it's an act of Parliament anyway now, the Victims and Witnesses Bill. So
yes, no, but it wasn't
Act.
just the Victim and Witnesses Bill. It was how human rights can go through all committees, not just the Justice Committee. And Ms McCall had given us an example of it. So I'm quite happy with that. And I'm sure John maybe pick up on the police issue. I know he's next to speak.
As it comes, and you're taking over as well now. It's another moment. John, followed by Margaret.
Okay,
John.
thanks very much, Convener. Morning. I know you await your invite from Lord Bonamy's committee there, and with the purpose of monitoring the reforms. We value the input we get from you when we are going to scrutinise legislation. Can I ask, is there any engagement in advance of that with officials in the compilation of proposed legislation? And if there is there any conflict associated with that for your further involvement with that legislation as it develops?
No, I mean, I'm pleased to say that in recent times there has been more engagement between bill teams and the Commission, so that at an early stage human rights, as Sheila was saying earlier, can be on the table when policies and legislation are being formed, rather than at the end where positions can become more entrenched and it's more difficult to be persuasive and open up minds to the need to ensure that measures are compliant with human rights. So that is taking place, and it's to be welcomed. I think also that in the mapping of how human rights are realised in Scotland, some other issues relating to the Parliament did also come up about how the Parliament might want to consider can it do more to raise the level of awareness and understanding and know-how in terms of implementing international human rights standards and practice. So, more analysis given when it's said that a bill is human rights compliant. Maybe why do you say that? What are the reasons? So that there can be a more informed and measured debate about that. So there are a number of ways in which we think it's a shared responsibility. All of us can improve the way in which we engage with human rights. And the earlier the stage, the better.
In the equal marriage debate, there was much use of the phrase hierarchy of rights. And I wonder, can you tell us if there is such a thing? And in these times of economic restraint, should there be a prioritising of one set of rights ahead of t'other?
Human rights are not a fair weather friend, so in times of austerity they don't leave the table and only come back when things are better. In fact, you could argue there's more compelling reasons that human rights should remain on the table in times of austerity. And again, the frustration is that there is a lot of international best practice, very practical as to how, in times of austerity, when tough decisions do have to be made and very pragmatic considerations taken, that how that should be done in a way that respects the human dignity of all those who can be impacted and ensures that the measures taken are the minimal necessary, don't impact disproportionately against the least resilient to them, and that the maximum available resources in a budget as a whole are allocated towards meeting these needs to live a life of dignity. So that there can be the temptation just to put human rights to the side when the going gets tough. And that is certainly not what human dignity and international human rights legal system require. Is there a hierarchy? That is a sort of slippery slope and not one that we should be going down. I think the whole experience of the SNAP process and identifying what needs to be done is that it is a question of finding the means of reconciling what can be competing interests and claims and sets of rights in a way where a consensus can be achieved, and human rights principles of proportionality can be the mechanism for achieving that. So human rights have a lot more potential than is perhaps realised for reconciling differences that on the surface would appear to be mutually exclusive. The question of corroboration is one example of how the rights of victims of domestic abuse, etc., and the right to fair trial, they can be reconciled if that broader human rights context is applied.
I stand to be corrected in this, but I understand that the Welsh Assembly embedded the rights of the child in part of their legislation. If that is the case, can you see what the benefits are of that then? Because people want to know that it's meaningful at the end, rather than just, if you like, an academic exercise. So what difference would there be for the children of Wales as a result of that?
Well, that's true what you say about Wales, and it was a lost opportunity for Scotland not to at least replicate what's done in Wales, if not go beyond that. UNICEF recently brought out a study looking at the experience of how the UN Convention on the Rights of the Child is implemented in a wide variety of countries, a wide variety of ways. And it found that where there was incorporation, i.e. put into domestic law in the same way that the European Convention has through the Human Rights Act, then the outcomes were better, that there was a much deeper understanding amongst children, amongst families, amongst the public, amongst policy and decision makers and lawmakers as to what this actually meant. And it was more than just we should do it when we think it's appropriate or when it can be done. So the experience internationally is that incorporation of treaties like the UN Convention on the Rights of the Child does lead to better outcomes for children primarily.
And finally, if I may, on the question of the police, police officers who joined Police Scotland now swear an oath which includes human rights. I don't know if there's been any engagement with yourself or with Police Scotland and what that actually means and how it should be delivered in training. Has there been engagement, or would you be prepared to engage?
There has been very constructive engagement between the SNAP process and Police Scotland, who, as is in the publication, committed themselves to a programme of further embedding human rights into the culture and accountability of the police, with a specific commitment to develop human rights training of police officers. So to put flesh on the bones of the oath, as you say, is now being taken. That will be, as Sheila said, one of the early, easily measurable progress indicators as to whether that training and how that training is implemented and what difference it's making to the culture that we want to see, and which Police Scotland have also said they're committed to developing through SNAP. So very constructive engagement to date, and that again was one of the early measurable indicators of progress of SNAP.
Thank you very much.
Thank you. I've got Margaret, followed by Roderick, then Alison. Margaret.
Good morning. There's been quite an emphasis in your opening remarks, Professor Miller, on the collaborative work, the working together, the evidence-based. But what legal status does SNAP have, and how can it ensure that public bodies are actually adhering to it?
Yeah, very, very searching question. The legal status is there, but not as fully as it should be. The legal status is there in terms of, under the Human Rights Act and the Scotland Act, there is a legal duty of all public authorities to comply with that. And we all know that. Parliament is one of those. But what SNAP is introducing is not just those rights contained in the European Convention, but the broader rights that all of us need in order to live a life of dignity. So the right to adequate standard of living, adequate housing, highest attainable standard of health, rights of children, rights of disabled, rights of women. They make up the set of international human rights that the UK has recognised, but hasn't given all of them the status that has been given to those rights within the European Convention. So one of the things about SNAP and one of the innovation forums to be held later this year will be taking a stock of what has Scotland and the UK done in incorporation of these broader range of duties. What would be the benefits of incorporating further treaties which are seen internationally as being necessary and recommended by the UN? What's the experience of other countries that have done that or are thinking of doing it? And therefore, what's the best way to proceed within Scotland, no matter what the outcome of the referendum is? So that is one of the early innovation forums to begin to look more broadly at giving the proper status to all of internationally recognised human rights, which would lead to better outcomes and benefit for people, especially the most marginalised.
You mentioned specifically the Scottish Parliament. With a government majority, how can we ensure that legislation is accountable, and in particular priority 6, which is to enhance the respect, protection, fulfilment of human rights to achieve justice and safety for all is achieved, because outcomes you've emphasised is where we're badly falling down, especially in the context, and there's been a range of things, court closures, police counter closures, corroboration, the introduction of criminal legal aid contributions. How can that be looked at in the human rights forum?
For the first 8 years of this Parliament, there was also a government majority under a coalition, and there was only a period of 4 years when we actually had minority government. So, unfortunately, or fortunately, as the case may be, we've had, something like 12 years. What would it be? It would be 10 years of government majorities. That's just to put it on the record. People forget we had one for 8 years as well.
I think the point there is we've got a majority government with no checks and balances. Coalition, to an extent, was a check and balance.
Well, with respect, I was here those 8 years, and I can remember never getting a single amendment through practically. So, I think, in fairness to whoever's in power, that was the position historically as well. Now, I want to move on. I think I've made the point about 8 years of majority previously.
Convener, I think I did this before when Jenny Mara was there. It doesn't matter what party you are. We all believe in human rights. I'm not here to talk about just the government's position. I think it's a cross-party. And for someone from a party put forward a benefit tax.
No. I'm not into
bedroom tax and benefit cuts.
Jackets off. Jackets off. You see what you've done, Professor Miller. Human rights. I don't know how to get a balance in here of human rights. Proceed anyway. Please do.
Well, picking up the point that Margaret Mitchell made, I think that one of the ways in which, the public wanted Parliament to be at the outset was to be as big as it could and be above partisanship and look towards the public interest and benefit. Part of that, as we've been saying, is looking at the broad international human rights experience and duties that are placed upon a Parliament and a government through treaties that it has signed internationally. And as Sandra White says, if that is given more prominence in the deliberations of Parliament and government, i.e. a bigger set of values, then it is more likely that those values will actually be applied in legislation and policy. So human rights plays a part in the Parliament accepting its bigger responsibility to the public and to improving the outcomes. In terms of the point you make, which is clearly quite an interesting, lively point about majority-minority, the Commission was very pleased that the Justice Committee agreed by a majority on corroboration and the Criminal Justice Reform Bill. And I think that set an example. Whether you agree or whether you disagree, here was a committee that took a lot of evidence and came to a view which didn't reflect the parliamentary majority. And that was something that in and of itself showed a committee looking at bigger responsibilities. So welcome that.
On a different point, I think John Finney mentioned a hierarchy of human rights. If not a hierarchy, then when some of the human rights compete against each other, for example, private and family life the right to and access to justice and the right to an effective remedy. Now, I don't know if we're straying a little bit onto reserved matters and if SNAP still can look at this, because if you're looking, for example, someone who's married and has committed horrendous crimes and is up for extradition but claims the right to family, how do you judge and tackle these huge problems? They're very much live.
Thinking of a hierarchy of rights, I'd agree with Alan, is not the right way to think about it. We just confine ourselves to convention rights for a moment, because those are the ones you've referred to. There are some of those rights, as the committee well knows, I suspect, that are absolute rights that have to be respected, and there are others that are qualified rights, as they're described. In other words, yes, they are rights, but they can be interfered with in certain circumstances by the state. Access to justice under Article 6 is an absolute right. There's no equivocation about that. There must be access to justice. There must be a fair hearing. There must be a fair trial. The right to private and family life, on the other hand, is a qualified right. So yes, someone has that right, but the state is permitted to interfere with it, provided that's necessary. It seeks to address a pressing social need, and it's proportionate in the way that it's done. So it's the least measure necessary to achieve a legitimate purpose. That would normally be, in the sort of example you're talking about, perhaps the prevention of crime. In the sorts of cases you're describing, extradition and so on, the investigation of crime. So when those sorts of qualified rights are competing with each other, and one example that we see perhaps, just going back to the equal marriage debate, is the right to private and family life and the right to freedom of expression. Those are both qualified rights. What the Parliament has to strive to do is to fulfil everyone's rights, but where there has to be a balancing, it needs to apply that test of necessity and proportionality and think about the purpose of what it's doing in order to come to that balance. And these are not easy questions.
No, that's very helpful. And just commenting on last, I certainly hope the apology bill can be progressed a little bit, because I think it has huge potential to address some of the human rights of historic survivors and others.
If I may comment on the balance of rights, which I think I refer to off at run hierarchies, the balance of, apart from the absolute ones, let's say you refer to under ECHR, we had an interesting discussion earlier about the Regulatory Investigatory Powers Act, where there's intrusive surveillance and covert surveillance, and I think that's an issue the committee may be interested in pursuing, because that's an area, quite a cloudy area, where individual rights, freedom of expression and movement and so on, are balanced against those of the state, and it's quite difficult for parliamentarians to really find out how that balance is operating. So I just thought I'd let you know we had an earlier discussion about it, and I think the entire committee was quite interested in having a look at this area, subject to our other work programme. But that's an area, again, as I say, where that balance is difficult to actually get underneath and find out if it's the right balance that's happening, let alone how much it's happening. Can I take Roderick first, John, before you come in? Because Roderick's not been in. Alison. Roderick.
Morning. Professor Miller, towards the end of your introductory speech, you talked about monitoring international human rights recommendations. Perhaps add a bit more flesh to kind of what we as a Parliament could do to be kind of more aware of what's going on in that international environment.
Yes. 2 years ago, there was a conference which agreed the Belgrade Principles on parliaments and national human rights institutions and human rights more generally. And it made clear that Parliament does have a shared responsibility in the promotion and protection of human rights. Part of that is holding its government to account in terms of how it executes the judgments of courts, like the European Court of Human Rights, how it responds to recommendations from United Nations treaty committees who are looking to see how these treaty obligations are being implemented within all the countries around the world. And so Parliament has a responsibility in and of itself when it's considering legislation or considering introducing legislation, to make sure it's compliant with that international framework, but also to hold the government to account and have it account to Parliament as to how it is implementing the obligations it has under international human rights law. And Parliament and the National Human Rights Institution are the natural partners in raising that scrutiny standard of implementation of international human rights recommendations. Later this year, under the Universal Periodic Review, which is where the UN every 4 years looks at the entire breadth of all the treaties comprehensively, Scotland and the UK will be taking stock of sort of mid-term as to how it's applying these recommendations. And then in 2016, a full report has to be given to the UN on that. And SNAP will be a very important part of how Scotland is able to report how it's progressing, but also be held to account constructively internationally as to what progress it's making and whether it's enough.
What do you foresee as the kind of the likely outcome of the Universal Periodic Review mid-term this year?
Well, I think from Scotland's point of view, there's a real opportunity to be able to demonstrate through its commitment to implementing a national action plan, which in itself is based upon the recommendations coming out of the last Universal Periodic Review. If Scotland seriously implements this plan, it puts itself in a very good position for being able to hold its head up high within the UK and internationally, that it is seriously engaging and is set the right direction of travel for implementing its international responsibilities.
Do you think there'll be some negatives from the review, though, as far as Scotland's concerned?
Well, it depends on what is done, but you know, the sorts of areas that will be looked at will be such as the age of criminal responsibility. That is one that has attracted attention before. More broadly, the UK and therefore Scotland will again be held to account for not implementing and incorporating international human rights obligations. That's been a historic request made of the United Kingdom, and it will continue to be made until such time as a change is made. And again, having this innovation forum where Scotland can look at the merits and benefits and mechanics of doing that, it would be a very, very significant step forward and would be well received by the United Nations.
Alison, followed by John Finney again.
Thank you. Well, we're just following on from Roderick's point there. I mean, and you said that we need to get better at listening to international voices, and CADR happened because we were stone deaf to what was being said to us. I mean, what is the next CADR? I mean, is it the justifiable assault, for example? Would that be something that we really have been deaf to until now and we need to take urgent action on?
That's the existence of a justifiable assault defence in relation to violence against children is something that has, as Alan described it a moment ago, historically been repeatedly mentioned by international bodies, the committee that looks at the Convention on the Rights of the Child, and so on. So there are these issues that recur, and sometimes they recur across a number of treaty bodies in the UN. And it would be wise to pay attention to them and to try and start to tackle them rather than wait for a reactive situation like CADR.
So as Parliament starts to mature, and we're in a reform process in Parliament at the moment, what sort of mechanisms ought we to set up in here to actually actively look at these things? I mean, is there a formal process that we need to bring into Parliament?
Well, I think Parliament can more engage constructively with the international human rights system through simply becoming more aware of how it works and what its share of the responsibilities are. That can very best be done through this through a relationship between the National Human Rights Institution and Parliament, because you established the National Human Rights Institution to be that bridge between the international human rights system and the domestic situation. So we will make reports, as we do, to the UN about how Scotland is or isn't implementing its obligations. The UN will respond to that, listen to what the UK government and Scottish government says, and then make recommendations. If Parliament then sort of charges itself to look at these recommendations and say, yes, there are learnings here, what are Parliament's share of the responsibility? What do we expect our government to do? How can we work with the National Human Rights Institution to sort of measure progress and set that direction of travel? Then everyone has a part to play. And if we all accept that, then the cadres are much less likely to happen in the future.
A couple of other questions, if I might, Convener. You explained that the development of the National Action Plan was quite a long process, and you were at pains to tell us how inclusive it was. Does it surprise you then that we've seen, I mean, you had engagement with Police Scotland, you've said Police Scotland have said that they will take steps to further embed human rights. But given that all of that involvement that had been there and the growing awareness about human rights, does it surprise you that at the same time as that was happening, we've seen the rollout of stop and search across Scotland, which is raising questions about legality and proportionality? I mean, it seems to me that there's two different things happening there.
Yes, and I don't think the two are unrelated. One would expect that as the Police Scotland goes down the road of embedding human rights into their culture and accountability and providing training to officers about how to discharge the very extensive powers that we give them, quite rightly so, but with expectations that they're carried out in compliance with the human rights of those that they are policing. So, for example, Sheila and I have talked quite a bit about proportionality. That's not just a necessary tool for policymakers or lawmakers to try and reconcile competing rights. It's also for police officers who are given a very difficult job. On the one hand, we want them to take away people's rights when it's necessary. On the other hand, we want them to respect human rights. So I'm not minimising the challenge that police officers have in protecting and promoting human rights, but it's what they have to do. And the more operational understanding there is of proportionality, then you would expect that the approach towards stop and search would reflect this increased understanding of, is it proportionate to stop someone in the street where there's no reasonable grounds to suspect a crime has been committed and seek their consent, perhaps of someone who may not really be in a position to give consent to them being searched. So it is one of the areas in which there's no wall between improving the operational understanding of human rights by the police and all public bodies and the commitments to SNAP, and then measuring what the outcomes might be.
And I suppose my final question is related to that. It's about the action group and about what level of buy-in you have to the action group and how empowered the people are that are in the action group to go back to the local authorities or the public bodies and actually take that best practice back and get it to happen, because there's a lot of groups around and there's a lot of talking shops. So how do you make this actually really properly work as an action group rather than a discussion group?
That is the challenge, and you and we and everyone will be the judge of what progress is made on that. I think one of the ways in which SNAP is trying to ensure that it's different from maybe other traditional action plans where they can often be anticlimactic is that these human rights action groups and the leadership panel will ensure that the place of what we call rights holders, those who are the most disadvantaged, the most marginalised, that they're around the table and they are constantly bringing to the attention of those decision and policy makers, look, this is our living experience. We know we have these rights. Why are they not being respected? Why are they not being fulfilled? Let's do this together to make sure that we all understand how this can best be done. And we are the we're the test of the effectiveness of that. So rather than have a separate process of those making laws and policies here and those out in the communities there, it is bringing them into the same process, and that of constructive accountability and independent monitoring. And you know, the measure of the success so far with SNAP is that we've been able to agree an action plan through that very process. With historic child abuse, we've been able to agree an action plan through that very process. So we want SNAP to write that large.
Thank you.
Go on.
Professor Miller, the convener alluded to RIPSA, the Regulation of Investigatory Powers, and there is to be a Scottish Government consultation on that. So my question is twofold. Are your good selves involved in responding to that? And secondly, we heard in this private briefing we had before the meeting this morning some interesting facts, including the term collateral intrusion. And I'm wondering, where is there such a thing as community rights, for instance? Is that something that you could pick up? I hope, as the convener says, though it's not been decided, that this is something that we can follow through, because I think there are a range of issues. Our ability to pick up in all the agencies, particularly the UK reserved agencies who may be using or abusing these powers, I think is going to be challenging. But can you comment on community rights, if there is such a thing, please?
I'll comment, if that's all right. In relation to your first question, we're aware of the consultation and the draft that's been circulated and so on, and we will make a response to that in due course. But as you identify, and as the convener identifies, it's a very complex area of interrelated rights and responsibilities. The phrase collateral intrusion is one that's familiar, I think, to those that operate in the RIPSA system or have some encounters with it. I'm not sure that thinking about it in community rights terms is necessarily the only way to contemplate that, because what collateral intrusion really refers to is who is going to be caught up in this surveillance that is not the target of it. And all of those individuals who are caught up have individual rights to privacy and so on. So whilst one might think generically of the community, and I think that's an interesting way to think about it, underpinning that are a whole series of individuals with their individual rights that have to be respected. And that's maybe another way to look at it.
Thank you very much.
Now, I think that's us concluded. Can I thank you very much for your evidence? And I'm going to give you would you like a 5-minute break or a 10-minute break? 7-minute break. Takes you up to 11:50, then we'll take our next item. Right, thank you. Right, thank you very much, everyone. You had a little break. It's consideration, item 4, consideration of 7 open petitions. I'll go through each in turn as they appear on your paper. Paper 3, P1280 and P1427. We previously agreed to wait primary legislation in respect of the first 2 petitions. The first is on fatal accident inquiries and the second on multi-party actions. The Cabinet Secretary has said he will bring forward legislation on fatal accident inquiries in this parliamentary session, and the Scottish Government intends to address multi-party actions in its response to the Taylor Review. Are you content to note the current status of these 2 petitions and keep them open? Yes.
Do we have I mean, I know that it was last considered on 25th of September 2012. I just wondered whether we had any indication from the Scottish Government about timescales in terms of legislation.
I seem to recall we asked the Cabinet Secretary during the process of a bill, but I'm seeing...
In this session? The one on fatal accident inquiries in this session?
Yes.
This one is just when we get the response to the table.
Yeah, but when we say within this session, it has to be, I mean, they've obviously got to instigate it within a timescale so that the legislation can be enacted. So at the very latest, what would that be? 18 months or something? About 18 months at the latest. Roderick?
That's not actually necessarily the case in relation to P1427.
No.
Back to the same point, we don't actually have a response from the Scottish Government to the Taylor Review. So,
right, so do we wish to just ask the Scottish Government to note our continuing interest in these and give us an update?
I think we should.
Everybody agreed?
Yes.
Thank you very much. And they're still open. PE 1403, we previously agreed to consider this on support and assistance for victims of crime as part of our Considering Victims and Witnesses Bill. And of course the bill has been enacted. Therefore you contend to close this now. Thank you very much. PE 1436, we agreed to consider this in retrospective abolition of the requirement for corroboration as part of our considering of the Criminal Justice Bill. In our Stage 1 report, which is now published, we agreed that if the corroboration requirement was to be abolished, it should not apply retrospectively. Given that the Government and the Committee have both taken a position on this matter, are you content to close this petition now?
Yes.
Thank you very much. Closed. PE 1449. This is a petition of the Scottish Council for Administrative Justice. The Scottish Government has established an interim advisory committee on administrative justice and will assess how this works over the next 2 years. We have received further correspondence from the petitioners at Annex C, expressing concerns about the composition of the advisory committee and broader concerns about administrative justice. Can I have your comments, please, on whether you wish to keep this petition open to see how things work out with the advisory committee, or do you want me to close it on the basis that the Scottish Government is assessing the matter? Your views, please. Speak up, someone. Yes,
Convener,
Roderick.
I would keep it open for the time being. We still seem to be accumulating more information in relation to what's happening. And the Tribunals Bill has still got a way to go through Parliament, so this issue is still live, in my view, at the moment.
Anyone dissenting from that? Keep it open. Thank you. P1479 relates to the time bar for submitting complaints about solicitors. The Scottish Legal Complaints Commission has indicated it intends to undertake a consultation on all its rules, including the time bar, early this year, and has offered to consult the petitioner and any other groups suggested by the committee as part of this consultation. Can I have members' comments on whether to keep this petition open or whether you'd be happy to close it on the basis that the petitioners could be directly consulted as part of the SLCC consultation? I could see you revving up there, Alison. Yes.
Convener, I would prefer that we kept this petition open. I don't think we've thoroughly addressed the issues that have been raised, and while I note that the SLCC say they will consult, I would prefer that we kept it open until we were absolutely sure that they have properly taken on board the concerns that are expressed here, and I would be keen to encourage the SLCC to consult more widely than who they say that they're going to draw into their consultation.
Margaret.
Yes, I concur with that, Convener. I think it's worth keeping an eye on, therefore keeping open.
I have no issue with that. I think that's perfectly reasonable. Right, so we keep it open. P1370 calls for an inquiry into the McGrahy conviction. As members know, the Scottish Government has no plans to undertake an inquiry into this conviction. Since our last considered petition, we've received further correspondence from petitioners for Police Scotland. In fact, you also will now have a copy of a letter from Police Scotland to Mr Robert Forrester dated Monday. Can I say here can I have your comments on how we take this forward and whether you wish to close it, John? And I'd like to come in myself, John.
Well, thank you very much indeed, Convener. As you rightly say, and it's at paragraph 31 in the papers which are available for public consumption, that the Scottish Government has no plans to instigate an inquiry. Now, I find that unfortunate, and if that remains a position, not least because it preempts some of the other matters I'm going to allude to. And I think very generously the Justice for Magrahi Committee attribute some credit to this committee for the Scottish Government finally admitting they had power and remit under the 2005 Inquiries Act after 18 months saying they didn't. So I think there are a wide range of issues around that particular aspect, but if I can touch on the 9 allegations that subsequently are made by the Justice for Magrahi Committee. These are allegations of serious criminality in what was a mass murder case. Now, we know from the paper we have here, the various stages that has taken. 3 of the issues are frozen. I think it's a matter of some considerable concern that the Justice for Magrahi Committee received no update from what was then done Fries and Galloway, which continues. We know, because you were directly involved, Convener, in writing, that DCC Pat Shearer undertook to get back in a matter of weeks. We were told, I think in September of 13, the same gentleman retired in October of that year. Now, very key to this is the role of the senior investigating officer, a pivotal role in any criminal inquiry. Mr. Shearer was that senior investigating officer, and the letter you allude to, which with incredible timing arrives the day before this committee meeting, sent to Mr. Forrester from Mr. Johnston, Detective Superintendent, intimates from this point forward, and that's a letter dated 17th of February, he is to be the senior investigating officer. So I think there's a very legitimate question. Who, for instance, was there indeed anyone acting as senior investigating officer between Mr. Shearer's departure and Mr. Johnston announcing his own appointment yesterday? In some respects, we could be very reassured in that letter by Mr. Johnson saying that the matters will be resolved by the end of March. Strange, given that he's unable to say how many officers are deployed on the inquiry. I think all of this, Convener, is extremely dismissive, a dismissive approach by the authorities to the Justice for Magrahi Committee, and I would suggest by default to this committee, which is an important oversight role. I think the timing of that letter is entirely cynical. What we've seen is procrastination and obstruction, and I would ask whose interests are served by that. Now, what we know is that the Police Scotland undertake criminal inquiries at the behest of the Crown Office, Procurator Fiscal Service, and I can't see them injecting any sense of urgency into this inquiry, given the nature of the matters that are being suggested. So whose interests are being served is maybe questionable. Our obligation is to ensure the public interest is being served. And can I suggest that some young man, the subject of a breach of the peace charge, may well wonder what sort of treatment he would receive from both these authorities if such a high-profile mass murder can result in this sort of response to legitimate concerns raised. The criminal ones reluctantly, I understand. And I think we must ensure that there's confidence in the criminal justice system. That's from those charged with investigating and those charged with prosecuting. It demands political oversight, this issue. I think this is the body that should be doing that. And for these reasons, and I await Mr. Johnson's update with great interest, I think we should maintain this inquiry open. Petition open, I beg your pardon.
Yes, I mean, I'm very cross about this. I mean, you talk about procrastination and obstruction. I call it long grass. I mean, if there's any strategy here with regard to the whole Magrahi issue, it seems to me to kick things into the long grass, wear people out, hope that those who are pursuing this fall off their perches and it all goes away. I'm angry on behalf of the committee because on the 24th of September, as you've referred to, this was a letter to Police Scotland. I was told it would be a matter of weeks when we'd be able to confirm the investigation had fully commenced. Now, we then get a letter in 4th November, already referred to by John, in which I'm told that DCC Shearer is now retiring. due to Police Scotland, but it's still not going to be a long time, and it will be assessed being weeks rather than months. Now that's November. Such is the urgency, as you say, that only on Monday does Mr Forrester receive a letter, it's just on our desk today, telling us that there have been recent developments in the live investigation, and now we're into March. On top of that, which seems to me extraordinary, I like this paragraph here. It says, with regard to the question of how many officers are currently working on the inquiry, and to know what stage the inquiry is, I am unable to provide you with definitive updates in relation to these questions, as they are currently being reviewed by myself. Now, how long does it take to find out how many officers are working on an inquiry and what stage it's at? It doesn't take till the end of March, unless Mr John Stuart Johnson, Detective Superintendent, has got a very busy workload. And I just see, I'm with you, I see obfuscation here. I think we should just be writing directly to the Chief Constable and asking him how many people are currently working on these updates, currently working on the inquiry, and what the position is with regard to what was another inquiry, and we would require an answer within, you name it, 7 days, 10 days. I think it's time we went to the top of the tree. This is nonsense. Now, I don't know whether committee members, whether or not you're sympathetic to the McGrahy petition, feel the same or not. He's waving at me. I don't know. I just think this is contemptuous of the committee. Yes, you're being told weeks, then it becomes months, then it becomes, I didn't ken, I've just got on the job. Not good enough.
Thank you very much. It's clear. I suppose I should declare an interest. I was on the Petitions Committee at the time we referred it to the Justice Committee, and I've got a great deal of sympathy with the situation, but I do want a wee bit of update myself and a wee bit of clarification. The terms of the petition are the Scottish Government to instigate an inquiry into Mr Al McGrahy's conviction. Now, we seem to have moved away from that, and it seems to be more an investigation how Dumfries and Galloway, if you just bear with me, please, Dumfries and Galloway are actually looking at this. I'm a wee bit concerned about that, and I'd like a wee bit of update.
Well, as the committee already, bear with me, the committee has already agreed to write these letters.
Chair, I just want a wee bit of clarification for myself. We're moving away from the original terms of petition. I'd like a wee bit of update on that particular one. I also wasn't too happy with the submission that came from the petitioners. I think it's 1, 2, 3, the fourth paragraph down, where they say, we are most disappointed in the apparently dismissive approach being adopted by D&G, I presume that's Dumfries and Galloway, to our allegations, and by dint the last consideration of the petition, the Justice Committee itself. So I'd like a wee bit of clarification on what they meant by that particular aspect of it. And I've declared that I'm very supportive we should get something done. And the third point I'd like to make, in a point of clarification, it's been mentioned about the fact that family of Bassett and McGrahy were looking to take this forward to the Criminal Cases Review. Can we have an update on that? Is that true, or is it just speculation from the press?
Can I just
These
say,
are just questions I want
can
to
I just say, first
ask.
of all, well, I can't answer that because I'm not giving evidence to the committee, but my point is the letters. I appreciate your point that the petition was about a specific an inquiry. However, we did write letters asking for clarification. And what I'm concerned about is, bear with me a minute, that when the Justice Committee writes and is told it will be weeks, and then it gets a letter back saying, well, we'll need to push it a wee bit further, but it'll still be a matter of weeks, and then we end up on the day of the committee sitting with something telling us it'll be March. I am concerned that if the Justice Committee is being treated in this rather offhand fashion by Dumfries and Galloway, goodness knows what is happening elsewhere. John, you're frowning at me, but...
Well, there is no such entity, convener.
Well, was Dumfries and
Galloway, but of course, things moved on the 1st of April last year and should have picked up. To pick up on Sandra's point, I use the term preempt because this is about the opportunity to look beyond, and I think the Scottish Government, you would almost understand there would be an enthusiasm on the part of Crown Office, Procurator, Fiscal Service or Police Scotland to thoroughly examine these accusations that have been made of serious criminality and put the issue to bed. But they're not even doing that. That's where the contempt bit comes in. And of course, you know, were any of these accusations to be founded, then that would most certainly have to be a matter of grave concern to the Scottish Government. So that's why I'm saying they're preempting the inquiry issue, and that's why we should keep this petition live.
Roderick.
Yeah, no, I just wanted to say my recollection of the history of this petition before this committee is that concerns were expressed, certainly by me and others, as I recall, that we shouldn't be really taking a definitive view on the petition whilst there was a possibility of kind of a further kind of review of Mr McGrahy's conviction. Obviously, Mr McGrahy died, and we have, as Sandra's referred to, kind of media speculation about what his immediate family or relatives are planning, whether they do in fact plan a further reference to the Scottish Criminal Cases Review Commission. I would have thought that we could make inquiry rather than relying on such speculation. Leave it to the Scottish Criminal Cases Review Commission to determine whether or not they're prepared to provide us with that information. But that was obviously one relevant factor. The other relevant factor that came in later in the day was the question of further inquiries as to the criminality of this matter being conducted by what was Dumfries and Galloway, now Police Scotland. And that remains the position. I don't disagree with what you, convener, and indeed John Finney have said about the attitude from Police Scotland as demonstrated by the correspondence, but we need to put the thing in perspective in the whole round.
And your position, therefore, would be what?
The position would, therefore, certainly to make inquiries of the Scottish Criminal Cases Review Commission, to keep the petition open for the time being, and obviously to express what discontent we can with Police Scotland in terms of the manner in which they've dealt with it.
Chief Constable.
Well, I don't have a problem if you want to write to the Chief Constable.
As I said, I declared the interest in it. You know, I'm not wanting to stymie anything, but we seem to have went off the track, and I would agree with what Rod has said. Let's try and get some. See what's
that's one part, but the second part is the way the committee has been treated with regard to correspondence to find out what's been happening with this other inquiry, and to be told weeks, then months, and now to find it's 5.5 months, and to have it on your desk the day we're sitting. Now, it can only be because we're sitting today. There's no accident that Justice for McGrahy received that letter in time for the committee meeting. Margaret.
Can I clarify the terms of the petition which asks the Parliament to urge the Scottish Government to instigate an inquiry into Mr McGrahy's conviction? And my understanding is that the Scottish Government has indicated it's no plans to do so, and in fact has suggested that it would be better if the review of the conviction was taken in the appeal courts. Now, whether the family choose to do that or not is something different. But I rather share Sandra's view. We do seem to be going off on how D&G or the Police Scotland has replied to the committee, and I'm wondering if that particular aspect could be referred to the police subcommittee, and that we could close the petition today, because the Scottish Government has said quite categorically there's no plans for review.
I don't think it would be competent to go to the Police Subcommittee, because that deals with the operation of the Police and Fire Reform Scotland Act. That's its remit, and dealing with the police part of that. So this is really not relevant to that committee. John.
How it handles complaints, convener, is that not relevant?
That would be a general thing on it. I think because we're dealing with specific issues here, I don't think the committee would be happy for that to go to the subcommittee. I don't know if it would be competent to do it. John and Christian.
It's my understanding Justice McGrahy don't see any role for themselves in the appeal to the Scottish Criminal Case Review Committee. Can I say why we should keep this open? Regardless what people think of the individual merits of this petition, since that point, significant criminal allegations have been made. Now, that if any of them prove founded, they would add weight and would have people both within Scotland and I think in the international community calling for the matter to be looked at. So I think it would be premature, regardless of what people think of the merits, when there is an ongoing live criminal inquiry, to assist proceedings just seems completely inappropriate.
Christian.
Yes, I just wanted to concur what you were saying, Convener, regarding the subcommittee. I'm not very keen to have a subcommittee. I want to know what happened, and I want to have the answer from Police Scotland. So I'll be following, use the same line. On the same time, I will be quite happy to leave it open, but maybe not to try to second guess what is going to happen with the petition.
I think can I suggest that one of the first things we have to do is, and this is just for you to consider, is that we have to, who would contact, but write to the family, so a member of the family, to ask if they intend to clarify once and for all whether or not they intend to make a further application to the SCCRC. Why not, John?
Where is the locus for the Justice Committee on that?
No, I think it
it's to clarify, it's to get that out of the way. It's one of the questions that was raised of why are the family not doing this.
But I'm not sure how that relates to the petition.
It would park any inquiry, because you would then have, if they make an application to SCCRC, then there's a prospect of it returning to appeal court and the whole thing being opened up again. Well, I was asked if I could clarify what the position was of the family. That's what I was suggesting. Rod.
The British Government's position, as I understand it, is that they think a review of the conviction would be best undertaken through an application to appeal in the courts. And it's only kind of effectively McGrahy's family that can pursue that.
Why don't we write and find out? Would you agree, therefore, that we should write and find out once and for all?
I'm quite happy to try and avoid media speculation to see if you can get a response, and to try and see whether the Scottish Criminal Cases Review Commission will confirm whether they have received such.
So rather than do that, let me just satisfy you. You want me to write to the SCCRC to ask whether they've received any application or any inquiries? As broad as that.
You can do that. Yes.
Right, that's the first thing. The second thing is with regard to the correspondence involved with Police Scotland. You wish me to write to the Chief Constable with a rather stern letter with regard to the time. It's not even to us. With regard to the information you were given, which we were told would be a matter of weeks, just to clarify that, and we haven't had it. You're shaking your head in agreement, Alison, and you're not.
No, I'm not shaking my head anyway at all. Yes, okay, right to that, but the point I'm trying to make is we have went off the whole issue of the petition.
As the government keeps telling us, we are where we are, and as we've asked and written and asked for information and had it pushed and pushed and pushed, I think we're entitled to say, can we have a straight answer, and let's have a proper answer within a proper time, instead of constantly pushing it to the side, and then it would be published and the petitioners would know about it, and that would close that matter. So that's... Elaine?
No, I don't disagree with responding to Police Scotland, whoever. We should maybe make it clear that Pat Shearer got involved once he stopped being the Chief Constable for Dumfries and Galloway Constabulary and transferred into Police Scotland. So it's not actually D&G Constabulary.
No, I understand that. It was a slip. But
the other point is that Sandra and Margaret are right. That isn't, in terms of the terminology of the petition, it was about persuading the Scottish Government to have an inquiry, and the Scottish Government has said, no, it doesn't think that's appropriate. So we may wish to do other things, but Sandra's actually right in terms of the petition.
Well, I'm being told it's entirely up to us whether we want to be flexible on a petition or keep to its narrow remit. But for the time being, what we want to clarify is, has any application or inquiry been made, an application by any member of the McGrahy family or anyone with an interest in legal terms with regard to further applications to the SCCRC for an appeal, and secondly, the Chief Constable expressing a rather, I don't know if you're angry, I'm angry, but you might not be angry, cross at the fact that we didn't even get a response. It went to the Justice for McGrahy, and despite us being told by weeks and months, just to clarify these are clarifications of factual positions. Content?
Is the purpose of writing to the McGrahy family to see if they don't follow the appeal, then we come back and we ask
No, we're not
government?
writing to them, we're writing to SCCRC. Right? And it wouldn't just be...
We have moved some considerable way off
closes...
this, and notwithstanding your very deep interest, which I understand in this, convener, then we have a huge workload here. This is the second time we've looked at that. It doesn't meet the terms of the petition. I would be inclined to say close it today, because we're going off at a tangent.
Margaret wants to close it. Who else wants to close it?
Look at the recommendation that came forward about the SHRC.
Right.
Writing
so the committee doesn't want to close it.
After that,
these are two factual things to find out. Factual, is any application being made to the SCCRC or any intimation of an application to the SCCRC, and how many policemen are working on it, and what's the status of that? And once we get that information, these are just facts.
Isn't that only relevant, convener, if we think the government is going to change its mind?
Well, as I said in the initial thing, it's entirely up to the committee whether they want to keep within the strict limits of a petition to the Parliament or to expand it, because quite often petitioners bring them forward and don't realise they're fencing themselves in. I'm not taking one view or the other here. This is not because I have a personal interest. This would happen in any event. So can we settle in the SCCRC and move on and to Police Scotland, the Chief Constable? I've got a pile of people want to come in. John?
Well, I'm trying to...
agreed.
I certainly agree with both your proposals, Convener. And on Margaret's point there, I would say, whose interest would be served by that? What we have is we have... at the very best, let's say, very loose administration of this process. Process that would inform the position both of this committee and the Scottish Government with regard to an inquiry on the back of 9 serious criminal accusations. Now, I go back to my laddie that's charged with breach of the peace. If we can't be seen in such a high-profile case as this to be ensuring that the authorities act appropriately and at the very least with basic courtesy and get back to the people, then what does it say for the prospects of people, particularly against a background of the potential removal of corroboration?
I don't want to have a discussion on open and closing because apart from one person, the committee has not said they want to close it. It's still open. These are the 2 matters you've said, SCCRC and Police Scotland Chief Constable. Can we stop at that, or are there any other issues? Because I feel that that's the 2 factual things we're going to find out. John? No. You're not Roderick Christian?
Yeah, I just wanted to say...
I don't want to talk about whether it's open or closed.
I do agree with Margaret on one thing. Is once we receive the 2 answers, maybe we can discuss to close it or not. I would love to have that.
Yeah, I'm basically happy with that. But I mean, I would have just said it, and I'm not speaking for the government, but I think their position was that if there's a possibility of any kind of criminal appeal proceeding, it would be inappropriate for an inquiry to take place.
Yeah. That we've decided. So, I mean, we've done with the further discussion another day, 2 factual things to find out. Don't want to have the discussion about the whole thing now. That's we move on to the next item on it, which is item 5, and we're moving into private session, so could I ask for the public area to be cleared, please?